So, good evening, everyone. Welcome back to our weekly webinar series. This one is happening on at a different time on Saturday, but it is in continuity of what we started last week, where we were discussing all the surfacey related cases. And we have with us Anil sir, Sanjay ji, and let's take it forward.
Thank you, Ankit. Namaste and good afternoon to all the participants. There are two reasons for which this timing of 1 p.m. on Sunday was changed. One, that we are celebrating 90th birthday of my mother, and she has achieved 90 years of hard work. So we are celebrating the results of her hard work. Secondly, the 1 p.m. That we thought before, that actually clashed with a very, very important event today, where the IPA of ICAI organized an interaction with the president of NCLT along with 5 NCLT members, and that was basically an understanding from the insolvency professionals about their position. So we actually went there and we attended that. So taking it forward, the surfacey, we have seen various surfacey judgments on Supreme Court. Various issues were clarified. One, that the tax dues are secondary. First dues are from the secured creditors. And in fact, we also had NESL managing director with us, who is the NESL is handling the IU, information utility. And in June 2022, there was an amendment in the regulations, and it was notified that any application which is submitted to NCLT, a report of default from information utility has to be submitted along with the application. And that's a key document, very, very important document for admittance of the application, because the default is recognized by information utility. And in that, we have seen earlier an amendment in 2019, and in that amendment, it was very clearly mentioned that the registration before IU by any security, not IU, SARSEI, registration before central registry of any mortgage, that will have the priority, and the tax dues, any other second charge, or any other lien on the property, like the lien on in the revenue records, all those would be secondary. So these are all these judgments, and we actually could find some of the High Court and Supreme Court judgments, mostly High Court, which are primarily on these issues. Since we have an objective of understanding insolvency, surfacey both. So because we are also trying to make our participants understand in what manner the surfacey is better or IBC is better. So as far as this tax dues are concerned, the position is same in surfacey as well as IBC, as well as the revenue records are concerned. If there is any lien on the revenue records, the surfacey will prevail. Similarly, IBC will also prevail. So surfacey in any manner is not having less privileges to the secured creditor. Rather, surfacey is still considered to be faster because of various changes and various amendments which has taken place, and various Supreme Court judgment that in the last week we have even seen that the district magistrate or CMM, they don't even have a power to adjudicate. They are simply to assist. As far as the adjudication is concerned, as far as the tenancy adjudication is concerned, that power either goes to DRT as per the changed act, or it goes to the writ petition before High Court. So with this, we can open our discussion today. Ankit, we have a PPT prepared by uh, our team, and we always thankful to our legal team. They assist us in delivering these episodes, and we are happy that it is, I think, 27th continuous episode from AAA Insolvency. And this actually will, because our banker uh, who are our uh, uh, regular viewers and listeners, they would actually understand that the SURFACI is not lesser than IBC. In today's judgments, we are covering these 7 judgments, and one by one, each judgment will come in front of you. So the first judgment is from Dena Bank versus Siddharth Pulses through Proprietor and others. And this judgment is from High Court of Bombay, and its judgment has come out of a writ petition. And this judgment is as recent as 15th of September 2022. The story is very long, and I will not take to all this story. I would simply say that it is a case where first the hypothecation agreement was entered by one bank, and that was one bank with very small facilities. And then later on, some goods were lying at Maharashtra State Warehousing Corporation. Uh, the borrower has kept some goods at Maharashtra State Warehousing Corporation, identifiable goods, and then a hypothecation agreement was entered by another bank. So then a 4 crores of loan was given against these pulses, which was stored at Maharashtra State Warehousing Corporation. So the new bank who entered thought that it is a very clear security, identifiable security. It is stored with the Maharashtra State Warehousing Corporation. However, it was not a pledge, it was a hypothecation agreement. So there is a difference between pledge and hypothecation. Now, what I think the bank had made a mistake, because the Maharashtra State Warehousing Corporation, if it was a pledge, because the Maharashtra State Warehousing Corporation or wherever the goods are identifiable and separately available, it can also be pledged, because in that case, the lock and key and the possession will be with the lender. So in this case, it was hypothecation and it was not pledge. So in fact, the old bank who actually entered into the hypothecation agreement long back, he challenged before the DRT, and the DRT, in fact, the new bank and the DRT all allowed the sale of the hypothecated goods, and the sale proceeds were recovered, and the sale proceeds were deposited with DRT. Let's say the sale proceeds were for about 4 crores of rupees that was deposited with DRT. In the meantime, the old bank came, and old bank says that I have a original hypothecation, and my hypothecation is older than the new bank, and I have a claim. So the DRT in fact said, okay, you also take about 20 lakhs of rupees, whatever you have dues. So you also take those kind of dues. So that kind of order was passed by DRT, and then it matter went to DR80, and the DR80 said that so the DR80 even said that the DRT was not even justified in allowing this 19 lakh or 20 lakhs of rupees to the old bank who originally had the hypothecation agreement. So this particular case went to Honorable High Court of Bombay, and High Court, in fact, they were supposed to decide the DR80 matter. And finally, High Court decided in this case that the original bank who had a hypothecation agreement, and as per that agreement, all goods were hypothecated to that bank. So therefore, the recovery certificate which was given to the new bank, that was not really correct. So finally, the High Court said the mere direction. So let me finally go to the finally judgment. So the uh, petitioner bank had full notice of the factum. See, like what is the High Court said, that the new bank had full notice of the factum of pledging of the goods with the old bank. Therefore, the petitioner bank ought not to have extended any credit facilities to respondent number one. Respondent number one is a borrower, by executing hypothecation of the same or similar goods which were already pledged with the respondent number four bank. See, placing reliance on the hypothecation agreement showed that the goods were shown in the possession occupation of the borrower in that agreement. So, therefore, the goods were admittedly in the possession of the Maharashtra Warehousing Corporation, and on this ground, also hypothecation did not have any legal effect. The goods were stored in Maharashtra Warehousing Corporation. There could not be any pledge or hypothecation in absence of requisite warehouse receipt. So, prayed for dismissal of the petition with exemplary cost, inviting attention to the fact that even though the appeal was filed by the petitioner bank before DRAT, in the year 2010, the same was kept pending for removal of objection. That is one of the observation. So finally, the High Court held that no error has been committed by DRAT in arriving at a finding that the petitioner bank was not able to establish that the goods were free from encumbrances as on the date of execution of hypothecation agreement. So DRT was wrong, and the old bank who had the original hypothecation agreement survived, and the new bank could not survive. The new bank should not have extended any credit facilities. So that was the final, the held portion by the High Court. So this is a normal case where the priority of hypothecation was discussed, and even if the credit facilities were very low, even if the goods which was hypothecated by the new bank that was separately identifiable, separately stored, but still the hypothecation agreement was very clear that all goods similar to this was hypothecated to the old bank. Old means the first bank. So therefore, the second bank who came and provided a credit facility of 4 crores against identifiable goods, which were similar to those goods which were hypothecated to first bank. Therefore, the second bank, in fact, should not have granted. The rights of the first bank, in fact, survived. So, any comment by Advocate Sanjay Gupta or Ankit Goyal on this decision, which is a little longer because it actually went something like 20 years of litigation. Or we can go ahead with the next.
Sir,
I think we can. Yeah. Yes, Sanjay, please go ahead.
Sir, here I would like to seek your guidance and clarification. We practically come across certain matters, preferably in Punjab only, where the paddy, the sheller, we get the sheller cases under SARFAESI Act, and the paddy is, I think, mortgaged to the Punjab Financial Corporation, Punjab Food and Supply Corporation, and at the same time, it is mortgaged to the banks also. So in various some cases, the government, the Punjab Food and Supply Corporation, they had sealed the this godown where their paddy is mortgaged, I think. So bank could not take the possession. So in those cases, certainly bank would like to find the way out. So how they can be?
I think this judgment can be used. I am very clear. First, the borrower goes to bank, and borrower takes working capital facilities from the banks. So in that working capital facility, the borrower hypothecate all their stocks, irrespective of the location, irrespective of the storage place. Now the new things will come up. Somebody will say that there are some storage facilities. Somebody says that you can take loan from me because this is Punjab government or any of the companies with the objective of promoting or facilitating farmers. They would further say that we can also extend the agricultural loan to for the procurement of paddy, because the government's interest is to procure all paddy, whatever is produced by the farmers, and their money should be paid. So the borrower took it as an advantage, and instead of the existing hypothecation agreement, the borrower also normally go to these cooperative societies where they can get some money. And in case of default, those cooperative societies or any public sector and state government undertaking, they would seal the store. This judgment is purely can be applied that the all those goods where the banks has appointed us belongs to those banks. So this judgment can be referred and it can be prevailed upon that the first bank has all the rights and the second bank should have taken permission from the first bank in case the second bank or any cooperative state government undertaking, before they could have extended the loan, they should have taken some kind of permission from the first bank.
Yes, sir.
So we go on to Joy Kali Oil and Industries Private Limited versus of India. It's a High Court of Kolkata matter. It again very recent, 13th of September. See very clearly that it is a case where in fact we discussed that a case last time in the last Sunday webinar when we discussed that matter of R.D. Jain and Company, that was regarding the delegation of powers by DM or CMM to their subordinate staff. So in this case, the possession was taken in the presence of executive magistrate under section 14 of SAFESI, and the order was passed by the DM for taking the possession. And when it goes to single bench judge, so I think this is the single bench judge said the issue because what was the application? The application was that the taking possession or by executive magistrate is not as per law. The law says district magistrate. The delegation of powers by the district magistrate to executive magistrate, it is not valid. So in this case, the single bench judge said the issue as to whether the executive magistrate could be delegated the powers of district magistrate under section 14 of SAFESI Act is academic in nature, since subsection 2 of section 14 has been amended. I am sure that this particular case pertains to before amendment period. So therefore, the appeal was in fact submitted by it was submitted before the division bench of the Honorable High Court of Kolkata. The basic issue which was involved in that judgment was whether the impugned memo issued by the district magistrate under section 14 of the SAFESI Act delegating his powers to the executive magistrate for taking possession of the assets of the appellant is violative of the rule of law, illegal or invalid. So again, in this case, the High Court, R.D. Jain and Company versus Capital Trust case was cited, and it was a Supreme Court judgment that DM and CMM is the terms used in that section is not persona designata for the purpose of section 14 of the Act. The expression DM or CMM as appearing in section 14 of the SAFESI Act shall deem to mean and include additional district magistrate and additional chief metropolitan magistrate for the purpose of section 14 of the SAFESI Act. Thus, powers under section 40 of the SAFESI Act can be exercised by the concerned additional chief metropolitan, additional CMM or of the area having jurisdiction, and also by the additional district magistrate who otherwise are exercising the power at par with the concerned district magistrates. So the division bench of Kolkata High Court finally held that the authorized officer essentially exercises administrative or executive functions to provide assistance to the secured creditors in terms of state's coercive power to effectuate the underlying legislative intent of speeding the recovery of the outstanding dues. The authorized officer is not expected to adjudicate the contentious issues raised by the concerned parties, but only verify the compliances referred to in first proviso of section 14, and being satisfied in that behalf, proceed to pass an order to facilitate taking over the possession. The steps taken by CMMDM while taking possession of the secured asset and documents relating thereto is ministerial step. It could be taken by CMMDM himself or through any officer subordinate to him. Section 14 does not oblige the CMMDM to go personally and take possession of the secured asset. Therefore, there is no case made up. So I think this is very clear, Sanjay ji, that the CMM or DM, they have the power to delegate. They can delegate to the court commissioner, who can be an advocate. They can delegate to a Tahsildar, who actually would be working as a court commissioner in case the land and all that is agricultural land, and they can even delegate to their own office subordinates. But it is very clear that they cannot delegate to a PN or a clerk. So this has been finalized by various High Court judgment and also various Supreme Court judgment. Any comment from your side, or I can move to the next, which is a Supreme Court judgment?
Sir, it is very important that it is only the past 2 and 3 months only where the Supreme Court and various High Courts have come across with and clarified this position, because the banks or at various levels, the banks might have been facing these issues that they are refusing to take possession, or the borrowers are taking stay. So this is a clear-cut judgments are coming in the last 2-3 months.
So I think the SARFAESI is also kind of very clear now. Most of the hurdles are removed. Many judgments clarifying the positions have come. So the DRTs are also not giving stay. Our experience is that through SARFAESI, if it is not a going concern, the resolutions and the recovery is faster. What do you think, Sanjay?
Yes, sir. It is comparing to the IBC. Only one issue I see here in SARFAESI, that is a stay. If it is already granted by any authority, maybe DRT, High Court, or any other authority, if there is already a stay, then SARFAESI is difficult to implement at this time. Otherwise, SARFAESI is a faster. Banks are also giving us the opinions now that it is most of the hurdles by way of these amendments in SARFAESI, last 2 amendments, and by way of these judgments. You rightly said that, sir, DRT is giving very less stay. Even if they are giving, then it is for a very short purpose. They are not taking it longer. So only stay where SARFAESI can be delayed or hampered. Otherwise, it is becoming a faster tool now.
So IBC is, of course, suffering from delays. Like we have seen that 2019 application was filed in NCLT, the insolvency process started in 2021, then there was a stay, then there's litigation. So if IBC starts happening in 180 days, then of course it will remain advantageous. But if that doesn't happen, SARFAESI at least is the out of court process. So there is no possible delay from the court. The court can only delay SARFAESI process through a stay, as Sanjay ji is saying. So the pain points are the same in both the laws, that wherever the courts come into play and they take time in taking a decision, that's a problem. So I think DRT is also plagued with the same issue, that once a stay is granted, then the dates keep going on and the case is almost never heard till a long time. So that's what Sanjay ji is saying.
Yes, I think the SARFAESI is presently very efficient. However, for a going concern, it may not bring value, because it may deplete the value, because in case the company is not kept as a going concern, then it might end up into a trouble. But somehow, under SARFAESI, the properties can be sold faster than the IBC. Reason being, because in IBC, the first period of 270 days or 330 days is for resolution and not for sale. So in SARFAESI, the moment the account is turned NPA, all these actions can be taken. The timeline is provided. Going forward, the Bank of Baroda versus Parasaadilal Tursiram Sheetgrah Private Limited. It is a Supreme Court judgment dated 11th of August 2022. And the basic law point which was involved in this was 45 days time limit for filing application under Section 17 of the SARFAESI Act is meant for quick enforcement of security. So there is a section 17, and under Section 17, the borrower has a right to make an application before DRT within 45 days from the date on which such measures has been taken. Now, what are the measures? The measures are like physical possession, taking physical possession, or so Sanjay, in because this 45 days is kind of sacrosanct. However, there are many judgments which says from the date on which such measures has been taken, this date keeps shifting because the banks they take, in fact, the banks take various measures, and the borrowers find that the courts are admitting the appeal within 45 days of any such measures. Because I think you understand what I'm talking about. So what are those measures which the bank takes and the borrower gets an opportunity to file an appeal within 45 days? Any such measures that you can recall because of your practical experience? One I can understand is when the attempt is made for taking physical possession, or when the physical possession is taken, or when the sale notice is issued, or when the sale certificate is being issued. This is what I understand. From all these dates, 45 days can be given to the borrower. Any other thing that you can add, Sanjay, in this measures?
Sir, legally speaking, the right to invoke Section 17 by any aggrieved person, it is written in the law that any aggrieved person can move the application under Section 17.
Right.
Within 45 days of such measures had been taken. The measures is basically they talk about taking action under Section 13(4). That means the possession.
Yeah.
Other measures, practically speaking, every borrower, every person goes to the court and they try to take this stay based upon flimsy grounds. But actually, it is a action under Section 13(4) only,
Right.
where its right gets accrued. Other measures, definitely sale notice when it is served, when demand notice is served, so they can go, but their appeal doesn't sustain because the right doesn't accrue by that time.
So very right, very right. So this time limit of 45 days for filing an application under Section 17 is provided for quick enforcement of security. In this case, DRT first dismissed because the 45 days passed. Later on, DRT reviewed and accepted the application. Thereafter, DRAT set aside this order, DRAT, because the DRAT said that as far as the review is concerned, DRT doesn't have any power to review its own orders unless there is an error apparent on the face of the record. So DRAT said that there was no error because the 45 days are sacrosanct. Reviewing first dismissal by DRT, and that could not be done, that could not have been done. The writ petition filed before High Court challenging the order of DRT, the High Court stayed the DRT order and allowed DRT to proceed with the securitization application. So, but the High Court also allowed, that you can proceed with the application. The High Court also submitted that let it be allowed. Then finally, it came to Supreme Court, and the Supreme Court observed that the High Court was not justified in staying the operations of the order of DRAT. DRAT's order was right because the High Court said the reason for providing a time limit of 45 days, Supreme Court said the reason for providing a time limit of 45 days for filing an application under Section 17 can easily be inferred from the purpose and object of the enactment. In Transcore versus Union of India, this court held that SARFAESI Act is enacted for quick enforcement of security. It is unfortunate that proceedings where a property that has been brought to sale and the third party rights created under the provisions of the Act have remained inconclusive even after a decade. So this is a case where 10 years the property was sold. The challenge was made by the borrower. First challenge rejected by DRT, then accepted in review. Then DRAT also said that the DRAT again rejected, saying that the DRT has got no power of reviewing its own decision. Then High Court again accepted. So then Supreme Court rejected. So in all this process, 10 years, the person who bought the property, that particular sale remained inconclusive. So they were like once DRT accepted and then High Court accepted. DRAT rejected and then finally Supreme Court rejected. And finally it is remained rejected. So now what we have in hand is that this 45 days timeline is sacrosanct and it cannot be waived. And it is the right, and the waivers are not happening because of the objective of the Act, that is quick enforcement of the security. So this is what is the judgment. Any comment that you would like to add? 45 days period.
I think this again will give strength to this SARFAESI action. The timelines which are written clearly should be met. Otherwise, we saw in past many borrowers going, they file the appeal beyond the timeline is passed. So even then they have been getting the stays and different kind of structures against the bank in their favor.
Very right, very right.
I think this judgment can be used very well because the way the court has said that it should, the whole time issue that they have talked about should rather be, a regular part of almost all petitions filed before the DRT or the courts. Because this is important that the nature of the act and the expedite and the whole idea to expedite the process is captured in this judgment very well.
Yeah. On the basis of this judgment, the condonation of delay applications can be fought.
Yes, yes. So I think all our lawyers should know that this is the kind of protection against, because see, such cases where the property is bought by someone and it is not concluded for 10 years, that actually was a very big hindrance to SARFAESI implementation. So now we are happy that the courts are coming up with kind of judgments. So the SARFAESI is kind of settling down. I think that's a happy situation. Going forward, we have Bank of India versus the Secretary to the government. It is from High Court of Karnataka, and this was the against a writ petition, and this judgment was given on 6th July 2022. Now, very important subject. The claim of secured creditor under SARFAESI Act not affected by attachment under Karnataka Protection of Deposits Act. Now, this Karnataka Protection of Deposits Act, this kind of act is with all the states in India, because there was a mandate from central government that all the deposit holder, all these kind of unauthorized collection schemes, so every state should come up with their own act to protect the interest of the depositors. So every West Bengal has, the Punjab has, every state has the Protection of Depositors Act. Now, this is a case where a secured creditor, now I think this has got a resemblance with the case of State Tax Officer versus Rainbow Paper Private Limited, and of Supreme Court judgment under IBC. It is exactly a similar judgment because in case the SARFAESI also has this priority and the IBC also has this priority. I think there is nothing which can actually now prevent banks to recover their security interest in a faster manner. Now, in this case, the Bank of India challenged the order passed by the Deputy Commissioner or District Magistrate by which the application made by the bank under Section 14 of the SARFAESI Act seeking assistance in taking possession of the secured asset. The rejection was on the premise that the secured assets are attached. Now, what happened is the application was filed by Bank of India before DM or DC for taking possession of the secured asset. The DM or DC rejected to support the Bank of India because the DM said that there is a attachment on this asset by Karnataka Protection of Interest of Deposits in the Financial Establishment Act 2004. So therefore, the Bank of India filed this writ petition before the High Court. Now, the bank submitted to the High Court that the attachment under this Protection of Depositors Act 2004 would not have any priority over the actions of the petitioner bank. Bank initiated recovery action by issuing notice under Section 13(2) of the SARFAESI prior to the attachment under 2004 Act. Referring to Section 26 capital E, this is very important section of the SARFAESI Act, which relates to the priority of secured creditors and stipulate that notwithstanding anything contained in any other law for the time being in force, after registration of the security interest, the debt due to any secured creditor shall be paid in priority over all other debts. Now, whatever this registration, after registration of the security interest, this is what I was talking to. This registration is with SARFAESI, Central Registry, or Section 26 capital E of SARFAESI Act is very clear that all the security interest is supposed to be registered with the Central Registry, SARFAESI. So in this case, the SARFAESI action was taken in an appropriate manner by Bank of India. The security interest was registered with SARFAESI. Section 26E was fully complied with. Therefore, the observations of the High Court was very, very important. Ankit, would you like to read the observations in the light of this discussion? Because this is similar to what we have seen in State Tax Officer versus Rainbow Paper Private Limited in a Supreme Court judgment under IBC. Just can you read? Yeah.
It says Section 26E of 2002 Act makes it clear that notwithstanding anything contained in any other law for the time being in force, after registration of a security interest, the debts due to any secured creditor shall be paid in priority over all other debts. Relying on judgment of Honorable Supreme Court in Punjab National Bank versus Union of India and others were held that a reading of the above decision of the Honorable Apex Court makes it clear that the bank would have priority over all other claims. 2004 Act is a state act, whereas 2002 Act is a central act, which would make way for the bank to realize its dues by bringing the mortgage property for sale. The attachment of a secured asset under the Karnataka Protection of Interest of Depositors of Deposit in Financial Establishment Act 2004 would have no priority over the claim of the bank, which is the secured creditor, to recover dues made under the SARFAESI Act. Accordingly, the writ petition was allowed by quashing the order passed by the respondent. A direction was given to the Deputy Commissioner to consider the application of the petitioner bank filed under Section 14 of the SARFAESI Act without reference to the attachment under 2004 Act and pass appropriate order. So SARFAESI, so it is very clear, and SARFAESI. So those are two acts here which we need to be understood. There is the one provision with respect to the priority of debt is under SARFAESI Act, which is with respect to the hypothecation with the banks and with the secured lenders. There's another one or another provision which is under the RDDB Act. There are two provisions now which give a priority to the debt of the banks over the statutory or the state claims. Now, to imagine a situation that the SARFAESI Act overrides the charges which are mentioned in the acts, that is the GST Act or the State Tax Officer, the Gujarat Acts, and IBC does not, would be a very, very difficult scenario.
So I believe both are in this similar situation, like this judgment of State Tax Officer versus the Rainbow Paper that has also come as a surprise to all the practitioners of IBC, because in case the SARFAESI has already decided that the priority would remain with the secured creditors, IBC is changing it. Because these judgments are not first time. These are actually right from the beginning. Sanjay would be knowing much more, because you must have seen many judgments where the any other attachment has not been considered, and the rights under SARFAESI has actually prevailed in the past also. Not only this judgment, even earlier also, Sanjay, you would have seen.
Yes, sir. But it is after this notification came in January 2020 only. This section
Right.
26E.
26E.
Yeah. So only 2 years have gone. So since then we have seeing this kind of judgments. Similar judgment we actually saw last Sunday also, Jalgaon Sahkari Samiti Limited versus in Bombay High Court, where the commercial tax or state government tax dues were not considered as a priority.
Right.
So now in these 2 years, sir, it is a good development and good notification and good provision in the law that it is being treated at par with the IBC. So now we have been seeing these kind of judgments.
Good, Sanjay. I think we can move to the next judgment, which is E.K. Rajan versus the Authorized Officer, Canara Bank. This judgment is again from Karnataka High Court in May 2022. And the law point involved is the sale notice issued under SARFAESI Act without a 15 days clear notice is bad in law. Now, what the law says that there is a right available with the borrower. The borrower can pay and borrower can avoid the sale of the asset. That right of the borrower is protected, that the borrower can pay within the stipulated time, and that stipulated time includes, in fact, before the sale notice, before the auction. Now, in this case, the observations were that the three methods of serving, affixing, and publishing a notice of 15 days, because in this case, the 15 days notice was not served. This is the Security Interest Enforcement Rules 2022 says that there are three methods of sale notice being served on the borrower: serving, affixing, and publishing a notice of 15 days for subsequent sales. The first sale is different, and for subsequent sales, the 15 days notice is required, and for the first sale, 30 days notice is required. Is it correct, Sanjay?
Yes, sir. Yes.
So this is mandatory. First observation is this, and cannot be tampered with. The erstwhile provisions of Section 13, subsection 8 of SARFAESI Act gave power to the borrower to redeem the property, till the last minute before the sale took place. However, this has been changed in 2016 because most of the borrowers were taking advantage of the last day. Now the amendment was made in 2016 in Section 13, subsection 8, and the right of the borrower to redeem the property was made available only till the date of publication of the notice for public auction. So now the right of the borrower to redeem the property by making payment to the bank is only restricted to the date of publication of the notice. And once the publication of the notice is, once this notice is published, then that right is now finished. Since there was a failure on the part of the respondent to serve notice of not less than 15 days upon the petitioner, therefore the notice of sale was bad in law, and the consequent sale was liable to be set aside. The court thus allowed the writ petition of the petitioner and held that the notice of the sale was not served in accordance with the law. Observation says the reading of the proviso to 19 rule 9 sub rule 1 of the rules makes it explicit that the authorized officer must serve, affix, and publish the notice of sale of not less than 15 days for subsequent sales. For first sale, it was 30. The word serve relates to personal service of the notice. Affixture relates to the notice being affixed on the property, and the publication relates to the publication of notice in the newspaper dailies. The conjunction and employed in the proviso also indicate the mandatory nature of all three methods of notices. Further, in spite of the amendment to Section 13, subsection 8 of the Act, the proviso to Rule 9(1) mandates that the three methods of serve, affix, and publish the notice to be carried out within 15 days clear notice. No, even this was also argued that even if now the notice has been published, but it was very clear that the 15 days notice has to be given. So, Sanjay, like how many times that you feel that the banks have been making this error, that they are not complying with the condition of three methods of serving, affixing, and publishing the notice? I think this is an error which is a very, very common error before any sale is made. What do you say?
Yes, sir. I think in actually in more than 50% cases, they are not this adopting to all these three modes of service. All these three modes are mandatory. They are actually missing this serving the notice by way of the delivery by post. They generally miss this kind of service. Publish the publication they do, affixation we do and they also do, but service of notice by post they miss sometime. So there has been the instances where the borrower or the mortgager takes stay in this ground. Our cases have been.
To our banker friends who are listening to us, they should actually make it very clear that all the three methods of serving this 15 days notice for subsequent sales must be complied with. So this is very clear.
And secondly, sir, the right to redeem the property lies with the borrower, and he loses that right after the notice is published. But anyhow, the banker has this right with them. They can even cancel and compromise the matter even after the sale bid is successfully done. Then they can exercise their own rights.
So Ankit, should we go to the next one?
Yeah.
So Axis Bank Limited versus State of Gujarat. This is a Gujarat High Court special civil application, and this was dated May 22. And this order is also vindicating this is also something which is saying that the state tax officer versus rainbow paper is not something which is, that judgment has come as a surprise. Now let us say this particular law point in this judgment was state cannot claim preference over subject property, means secured asset for recovery of dues towards tax in auction proceedings of a secured asset. So this is again like the state tax officer against the state tax dues. Now the facts in this case are that there are borrowers, they availed loan facility, and the loan was bad, SARFAESI action was taken. The bid was finalized in favor of one respondent, number 5 in this case, and the property was put in his possession. So the possession was also given. The sales certificate was also issued, and the sale deed was registered in his favor by the bank. However, so everything has been done. All SARFAESI actions, the payment, possession, and the sales certificate and the registration. However, the bank approached the High Court since the state authority got its charge mutated in the revenue record. Now, after the sale deed is registered, when the respondent number 5, means the buyer, when he went to the state revenue records for getting the mutation done, then the mutation was rejected. The mutation was rejected by the revenue authorities. So in this petition, the Axis Bank Limited prayed for quashing and setting aside of the charge imposed on the attachment of the property by the respondent authority as illegal, unjust, unreasonable, and contrary to the SARFAESI. It was further sought that respondent number 6, this authority, record the name of that was the prayer, that the name should be mutated. Now, observations of the court. I think Ankit, you can just it is similar to I think in case you can collate this with state tax officer, it will be very, very interesting for the listeners that how it relates to the similar provisions which is there in the state tax laws, which is there in the rainbow paper. Please go ahead and
So
try to
it is.
explain.
So it says that the first priority over the secured assets shall be of the bank and not of the state government by virtue of Section 48 of the VAT Act.
If
The
you recall,
excess,
recall, the rainbow paper also refers to this section.
yeah, the excess, if any, shall be adjusted towards the dues of the state under the VAT Act. It is further declared that the respondents cannot proceed against the purchasers of the properties sold under the SARFAESI Act. Keeping in view the precedent cited by the bank, the High Court concluded that the state cannot claim preference over subject property for the purpose of recovery of dues towards tax, and this position of law was well settled. What came to be purchased by the writ applicant in the auction proceedings conducted by the Bank of Baroda was a secured asset under the provisions of SARFAESI Act. In such circumstances, the state cannot claim preference over the subject property for the purpose of recovery of the dues towards tax. It is not in dispute that the first charge was created in favor of the bank and the bank in exercise of its powers under SARFAESI Act. Accordingly, the High Court directed Respondent 6 authority to post and certify a mutation entry to record the sale transaction between the bank and Respondent number 5. Any entry of the state in form of charge in the revenue records also stood deleted. So it's actually SARFAESI Act, RDDB Act are already dealing with the priority of charges. If these priority of charges will not stay beyond SARFAESI Act, I think it should stay beyond any act, because if there are two acts, say SARFAESI and a state VAT Act, and SARFAESI Act is overpowering that VAT Act, then similar provisions either have to be brought in into IBC or similar legal position has to be held. Otherwise, nobody will favor IBC. IBC will go down the drain because in IBC one will have to give a first charge to the state. IBC will become impractical in case the rainbow paper judgment sustains.
Yes, you're very right. So because the SARFAESI now takes care of revenue records, tax authorities, it actually takes care of the kind of tenancy also. So SARFAESI actually is coming more cleaner as of now.
Yeah.
Hmm? Sanjay, what do you say?
Yes, sir.
SARFAESI is becoming cleaner, IBC is becoming dirtier.
So that is also a good fact, Ankit. Only the delay part is there in, by this appointment of more judges. I think it will also be more stronger. In the fear, sir, in the fear in the buyers is reducing now because of all these issues being settled very well by the high courts and supreme courts. So because after they, even if after they purchase, they have a fear in this mind whether it will be successfully transferred in their name, will be mutated in their name. So even then it remains in their mind. So by these judgments, they will be more fearless now.
No, you are very right, and we have the largest business of SARFAESI enforcement agents in India across the country. So we understand that these things, in fact, the SARFAESI was not really, banks were not really comfortable, but now the banks are very comfortable with all these clarities. So I think we are now coming at the last judgment of today, and the time is also up. Almost 3 minutes are left. Ganpat Pannalal versus State Bank of India. It's judgment from High Court of Madhya Pradesh, and it was delivered again as recently as 15th of September 22. Now, this is again a kind of it is on the powers of the DRT. So when this application was moved before DRT and by the borrower, and the DRT dismissed the application for want of prosecution. Therefore, the petitioner moved an application to restore the same. So when this application was being restored by DRT, the DRT actually imposed conditions that you deposit 2 crores in 4 installments within 2 months. Paying the first installment shall revive the interim relief granted prior to dismissal of the application. After payment of the final installment, the application shall be restored for hearing. Now, when this judgment was passed by the DRT and the aggrieved borrower actually went to went to Honorable High Court under Article 227 of the Constitution of India and assailing the legality, validity, and propriety of the order passed by the DRT. Now, the submissions made by the party, the petitioner submitted before the court that although the tribunal is competent to impose the cost, it was not justified in putting the aforesaid conditions. It was further argued that the said conditions were onerous and impermissible. On the other hand, the bank submitted that the DRT is competent to make such order and give such directions as may be necessary or expedient to give effect to its orders or to prevent abuse of its process or to secure the ends of justice. Hence, it was contended that the impugned order was within the ambit of law. Now, in this case, finally, what was decided by the High Court? So, Ankit, this is very interesting. The High Court even said that this kind of powers are not with the DRT. You can just read and add your comments on this.
So basically, here basically it says that DRT was competent as per Section 22 of the Act. DRT was competent to restore securitization application by imposition of reasonable cost. This power of restoration of securitization application cannot be confused with power flowing from Section 1925 of the same Act. Section 19 of the Act deals with application to the tribunal, and Section 19.5 states the tribunal may make such orders and give such directions as may be necessary or expedient to give effect to its orders or to prevent abuse of its process or to secure the ends of justice. When an application is pending in order to secure the ends of justice in that proceeding relating to adjudication of said application, appropriate orders may be passed in the interest of justice by taking assistance of Section 1925 of the Act of 1993. So, for example, if in a pending essay, ad interim relief is prayed for, the tribunal can very well impose justifiable conditions while granting such interim relief. Such an order will be in consonance with the scheme and the object of Section 1925 of the Act, as well as the judgment of Supreme Court in Mardia Chemicals.
So finally,
hence the restoration application filed under Section 22 to G could not be treated to be an application filed under Section 19 of the Act, and the Section 22 to G does not provide any power to impose the impugned conditions. The conditions of impugned order are tested as per the litmus test laid down in aforesaid judgment judicial pronouncements. It will be clear like cloudless sky that the learned tribunal has failed to exercise its discretion judiciously and impose conditions which are alien to the enabling statutory provisions. So basically, that's how they said that DRT has exceeded its mandate by going ahead with the applications that they had treated.
So this is what this was all for today, and we can see if there are some questions or in case anything that Sanjay would like to add, because we have seen in the last two episodes that where we discussed the SARFAESI latest judgments from Honorable Supreme Court and various high courts. We have seen that various judgments are coming, and amendments also came in 2016 and then 2019 and then in 2020. So all these amendments coupled with these judgments, I think the SARFAESI is more cleaner, much cleaner, and our banker friends, they should rely on SARFAESI, and this actually would be faster and clearer. Anything that you would like to add, because the time is also up?
Yes,
I think that
as we are handling more than 35,000 cases, so each and every step in so many cases we have practically came across all these kind of difficulties, and which will be now be clarified and are being clarified by the judgment. So it is, I think, will be very helpful for the banks, and wherever we go in the banks, we keep on apprising them also about the amendment and about the this advent of these judgments.
Sanjay, you can also take up with the banks that we are ready to provide any kind of sessions in the bank where they can actually, whosoever officer is handling SARFAESI, we can actually provide them our understanding and experience in any kind of webinar or in their training sessions. So you can also, yes, that will be from our side, we can do that.
Yes, yes, yes.
So great.
Can we conclude then?
Yeah, let's conclude then. Thank you, everyone, and looking forward to see you next week. And thank you so much for attending today's session.
Next week again is Sunday, 1 p.m. our usual time. And finally, it's a way forward for collective learning, and it's our way of learning. Thank you.
Yeah, thank you very much. Thank you.
Thank you.